Thank you very much, Amina, and thank you to the University of Richmond School of Law for inviting me. Thank you especially to Professors Walsh and Tobias for their roles in organizing this event. I'm really honored and flattered to be a part of this event, and thank you all for attending. What I'd like to talk about is what I conceive of as issues beyond the doctrine that are going to influence the Supreme Court's ultimate decision in this litigation. And the short of my thesis is that I think there are five basic considerations that the court will be taking into account, both consciously and I think to some degree subconsciously, that will shape its deliberations, and when we look back on this, are ultimately going to be the explanations for why the Supreme Court holds whatever it holds this coming June. So that's where I'm going with this. Let me start, though, before getting to that, to talk about a few sort of preliminary things. One thing I just want to mention, maybe it's implicit in all of us why we're all here today and why this event is organized, and that is why exactly this is so extraordinarily interesting as a topic. I think at least since I've been following the law and constitutional law in particular over the last 20 years, there's nothing that comes close to matching this litigation in terms of its combination of political interest, political intrigue, and the permeability of the wall between law and politics. The importance of the substantive constitutional issues, right? I mean, at some level, what's at stake is the basic structure of this quote-unquote experiment that our framers started back in 1787. What exactly is the role of the national government? What is the role of the states? And we've been fighting about this for 230 years. Richmond has played a distinctive role in that debate over the years. And yet it continues to crop up in very basic, fundamental ways. I think also, and maybe this is the part that I've been most intrigued by, is it's an incredible window into what moves judges. I can't tell you the number of times when I fielded calls from reporters where the first question out of their mouth has been something to the effect of, well, was it a Democrat or was it a Republican? Right? Who voted this way or that way with Judge Hudson or Judge Vinson, or the split on the Sixth Circuit, and what is the significance of Judge Sutton ruling this way or that way? This whole thing, this drama, as it's unfolded over the last 2 years, has been a great case study in terms of what actually moves judges in a highly ideological, highly partisan, political form of litigation. Secondly, in that vein, I think one thing I'm just sort of taking as a premise here is that in cases like this, and by that I mean cases of real high political salience, of deep, deep ideological commitments, what moves the Supreme Court in our history is not the nitty-gritty doctrinal distinctions of whether we characterize someone who decides to finance their health care by not purchasing health insurance and saving money in a savings account as being economic activity or not. Instead, it's much broader considerations. It is the role of the Supreme Court within our political system. It is the ultimate influence of the breadth of the national government relative to the states, the ultimate breadth of governmental power generally vis-a-vis the citizenry. It's considerations like that that I think ultimately drive doctrinal solutions rather than the other way around. And we can see illustrations of this over and over again through history, whether it's going back to things like Marbury and McCulloch or Dred Scott or the gold standard cases or the income tax case, Farmer versus Pollock, or Pollock versus Farmers Loan and Trust. Over and again, the Supreme Court is a court of law, no doubt, but it's also operating on a different plane in cases like this, and we shouldn't lose sight of that. Okay, with those things in mind, there are, I think, I started talking about some of these issues shortly after the lawsuits were filed. And I mentioned a few factors that I think could be important, sort of factors, extra doctrinal factors that could be important to the Supreme Court's ultimate resolution. But some of those factors have already been resolved, or at least they ultimately have turned out not to be factors in a way in which they could have. And it's worth mentioning those, I think, first. One is, if it had turned out, as I think many people thought on March 23rd, 2010, that after it became law, the Affordable Care Act actually became wildly popular with the American public, that the minimum essential coverage provision or individual mandate, whichever you'd prefer, was understood by the American people as being a necessary part of ensuring a much broader scope of coverage, a individual responsibility provision that people accepted was appropriate under the circumstances. I think we'd be in a very different place right now, right? There wouldn't be the political traction to continue pressing these lawsuits. There would be stiff resistance, popular resistance to the Supreme Court invalidating it. That hasn't happened. In fact, there was a recent poll that indicated, and I don't know the methodology here, but there was one poll that showed that a full 82% of Americans believe the federal government should not require persons to obtain health insurance. So what could have become a really important extra legal factor against the Supreme Court invalidating the act has not materialized. Second, the political standing of the president and of the Democratic Party more generally has not created a real stiff barrier to the Supreme Court invalidating the act. Again, we could imagine it may be difficult to conceptualize this, but imagine that things had happened exactly in the reverse in the 2010 midterms. And there were overwhelming majorities of Democrats in both the House and in the Senate, and President Obama was looking at overwhelmingly likely re-election in a year's time. That would put the Supreme Court, I think, in a very different position with respect to this case, because they would potentially be threatened institutionally by other power holders if they struck down what would be the central legislative achievement of the ascendant national political majority. That hasn't happened, of course. And so what a very important potential extra legal barrier has not materialized. Lastly, what's happened in the lower courts? One thing that, again, a lot of people were very curious about when this litigation started is, what does it matter what these district courts do if it's a pure question of law that is ultimately going to be resolved by the Supreme Court? What difference does it make what a district court judge in the Western District of Virginia or Eastern District of Virginia or Northern District of Florida has to say about this? And I think the one answer that was clear is if every single federal judge to have looked at this question had held that the act was constitutional, the Supreme Court would have been in, again, a much more difficult position to reject that position. If every single conservative Republican judge to have faced this had upheld the ACA as a valid exercise of the commerce power or of the taxing power, I think the court would have had a much more difficult time crafting an opinion invalidating the act. Again, it hasn't happened. So those are three potential extra legal influences that ultimately have not come to fruition, and that leaves us, I think, with five, shall we characterize them as considerations or questions that are going to be floating around in the justices' minds that are going to ultimately determine how they resolve this case. So let me walk through those five. Some of these are not really, they're not really extra legal, they're extra doctrinal. They're not down at the level of detail that the case is being argued by the parties. They're not at the level, really, of what the court's going to talk about in its opinion, but they nonetheless involve some jurisprudential factors. First, at a broad level, is this the kind of case in which judicial intervention is appropriate? That is, I mean, really since, I mean, you could go back much further, but really since 1937, I think, in the collapse, the demise of the Lochner era, a very basic question for the justices and for those of us who think about judicial power is, when exactly is it appropriate for courts to intervene and invalidate laws that have been enacted by our elected officials, particularly by a national electorate, right, by our national legislature signed by our president. Generally speaking, particularly when we're not talking about sort of quintessential discrete and insular minorities who are unable to protect themselves through the political process for structural reasons, there is generally a presumption, a strong presumption, in favor of constitutionality, of the court being deferential. Is that this sort of a case, right? Is this a case where the court really should be deferential because it is a highly politically salient issue in which the sides are very well represented in the political process, and there seem to be elections that are being won and lost on the issue, and that the political process itself can work out whether the act is constitutional or not? Or instead, you might see this, and I'm sure there are a few justices who see it this way, is this a case where the elected branches have a structural incentive to ignore our deeper constitutional commitments? They will inevitably be encroaching on state power. They will inevitably be aggregating more power. And therefore, it is incumbent, indeed, it is the duty and obligation of the court in a case like this to intervene. So that's a kind of a broad frame. It's not getting into the nitty-gritty of the doctrine, but I think how the justices think about sort of which box does this come closer to fitting into is going to affect how they resolve the case. Two, is this a case in which, a circumstance in which the states are, quote unquote, separately incompetent? Go back to this fair commonwealth's participation in the Constitutional Convention. The Virginia Plan, authored by Madison and Edmund Randolph, if I'm remembering correctly, had Resolution 6 in it, which talked about, it was a proposal for what powers should be granted to the national legislature. And in that, they specifically said it's critical that Congress be given the authority to legislate in areas in which the states are, quote unquote, separately incompetent. That is, where collective action problems and spillover effects, externalities, make it impossible for states acting alone to solve the problem. We need a stronger national legislature, right? The convention as a whole approved that provision. It was then referred out to the Committee on Detail. The Committee on Detail comes back a month later with the first draft of what becomes Article 1, Section 8, which is the laundry list seriatim of the different enumerated powers that the Constitution grants Congress. Now, there's a debate, big academic debate, about what exactly should we derive from that story. That is, was the effort to enumerate the powers individually, does it imply the negative that the broader separately incompetent language was implicitly rejected? But regardless of how we come out on that debate, there's no doubt that one of the chief motivating reasons for drafting and approving the federal Constitution was to allow the national government to deal with problems that are truly national in scope and in which the states are not competent to solve on their own because of these collective action problems. So I think a basic question that the justices are thinking about is this such a case, right? Is healthcare reform something that the states can pull off on their own one by one? Or instead, is it a problem that, for various reasons, It is simply impossible to states to pull off. It is a pressing policy imperative, and the only way it's ever going to happen, the only way we as a country are ever going to deal with it is through national legislation. Because, I mean, one thing, if they invalidate the mandate, is you potentially put healthcare reform, at least healthcare reform like the ACA, into a no man's land where the federal government is disempowered, but the states are practically incapable of doing anything because of the collective action problems. Third, a greater and lesser power issue. No one, including Randy Barnett, because I've talked to him about this, thinks that Congress could not adopt a single-payer system, right? Tax and spend and make everyone eligible for Medicare. Just expand Medicare to the entire population. That would mean a dramatically increased governmental involvement in the healthcare system over what the ACA proposes. Now, wouldn't it be, or maybe not, would it be just a little bit ironic if that sort of a system, much greater drift towards socialized medicine, in fact, it might be indeed, by anyone's account, socialized medicine, would it be more than just a little ironic that that sort of a system would be perfectly constitutional under existing power, right? Under Helvering versus Davis, the challenges to the Social Security Act, and yet a more modest, incremental, build on the existing market for health insurance, private health insurance, as the ACA does, is nonetheless unconstitutional. Or, if you want to think about it even further down the line, might it cut the other way? Might some justices be thinking, well, healthcare costs are not coming down. It's already 17% of our economy. Something's going to give, if not now, within the next 20 to 30 years. If the ACA goes down, I think perhaps one might think it's only a matter of time before we have Medicare for all. And therefore, maybe there is an incentive not to invalidate the ACA if you don't want to end up in a place where we have a single-payer system. Fourth, what's at stake exactly for the Supreme Court of the United States? The court, contrary to a lot of predictions from us academics, seemed to survive the whole Bush versus Gore thing okay. It didn't make much of a dent, if any, in its diffuse support among the American public. But it's not clear that that will sustain itself long term. That is, there is a school of thought that says the United States public's tolerance for the appearance of partisanship at the Supreme Court is a little bit like the tolerance for the venom from bee stings. That is, it's perfectly harmless up to a certain threshold, and then it becomes incredibly toxic. How does the court think about this problem? Particularly, I think, if, people have talked about, so Monday's conference has the 5 petitions up there from this case. It also has the challenge to the immigration law from Arizona, SB 207. It also potentially has the affirmative action case from Texas coming up before the end of the term. What if, how do the justices think about the idea of a 5-4 predictable partisan split in all 3 of those cases coming down within a couple weeks of each other in June? How does that affect how they approach this case or the other cases and managing that dynamic? Lastly, number 5, and I think at some level this is the most intriguing question, what does Chief Justice Roberts think about this? Exactly, in terms of not the merits, but his legacy as a Chief Justice. Go back to what he said at his confirmation hearings and the pains to judicial modesty. Go back to what he said in his very first interviews with Jeff Rosen and Brian Lamb, what he talked about, and how he seemed to be very self-consciously thinking about his legacy as a Chief Justice of the United States. Does he conceive of this as a case where he can show, in a way that every American on the street would understand, that the judicial power is truly different than the political power, such that judicial modesty is such an important objective and in such an important value in our constitutional system that even when everyone pretty much knows what he likely thinks on the policy merits, he nonetheless is willing to show the importance of judicial modesty by voting to uphold it, right? It's not our job to strike it down so long as a colorable argument is made that it's constitutional. Or instead, does he conceive of it, sort of tying back to the first consideration I raised, as a circumstance where no matter the reputational consequences to the court, no matter the reputational consequences to him, he needs to take a stand to stand up for these deeper constitutional principles, structural principles that the political branches in the long run will ineluctably ignore. And I just don't know. All of the questions I don't know the answers to. None of us, I think, know the answers to those. But what I want to do, and the aim of this, is to get us thinking to some degree about what's going to shape the court's deliberations. It's pretty easy, particularly for those of us who follow these cases so closely, to get really down into the minutia of what's being argued. And that stuff is interesting and has its place, but we shouldn't lose sight of the fact that what's really going to resolve this are going to be these broader questions that the court needs to come to some sort of repose on, and it's how it resolves these bigger questions that are going to inform and drive what sort of doctrinal solutions they come up with to decide the case. Thank you.
Good afternoon. Is this picking up? Kind of, sometimes? I would like to add my thanks to the litany, to Amina, to Professor Walsh, to Professor Tobias, to the entire editorial board of the Law Review. I very much appreciate the opportunity to be here today, and I think that the symposium has, at least until my contribution is added, has been an outstanding success. And I do stand here with a bit of trepidation, and I do that for three reasons. One is every speaker to have addressed the group so far has done such an outstanding job, and I really mean that. Number two, my comments drift dangerously close to the merits. Okay? So depending on how strictly the everything but the merits is enforced, I may get the hook. Number three, I just forgot number three. Oh well, so I don't have to worry about it. My claim is actually a very, that was it. My claim is facile. That was my third thing I was worried about. My claim is actually very straightforward. Okay, this is in the context, I offer it in the spirit. The Solicitor General of the Commonwealth earlier today quoted Justice O'Connor in New York v. United States, cited the decision. She also has a line in there where she says, some truths are so evident to us that they become invisible, like the air around us. And so I offer this observation in that spirit. This is the kind of thing that's not going to strike anyone as a novel insight, but I want to sort of draw our attention back to it and underscore it, because I think it actually is what is at stake in these cases. And my claim is, very straightforward. It basically breaks down into 3 points, and I'll remember all of them this time. Number one, the idea that there's a meaningful distinction between constitutional law and ordinary partisan politics is in, to use a health metaphor, in critical condition. Okay? It is on life support today. And I hope to sort of develop that claim in a bit, but I really think that's true. We are at a place where there's an ebb and flow in terms of the judicial and professional faith in the court to the court's ability and judges' ability to constrain themselves, and I think that we're close to a nadir on that. Number two, the way to deal with that cultural problem, and it's a problem of our political culture, it's a problem of our legal culture, and it's a problem of our judicial culture, is to recognize that we're in the driver's seat, in a sense. Really there in the driver's seat, that is, the judges and justices are on this, in that law is a socially constructed reality. And by our very acts, we either prove or disprove the possibility of courts to be something other than raw politics. And then number three, it's that this is a singular opportunity, I want to say sort of a once in a century, but again, Bush v. Gore, I think, presented the same opportunity, and it was passed over. But so maybe once in a decade opportunity for the court, by its action, and particularly the conservative justices by their behavior in these cases, to do an extraordinary amount of work towards rediscovering and reestablishing that distinction, both the faith in, the belief in the distinction between constitutional law and ordinary politics, but also the underlying reality that it is in fact characterizes the way our system works today. Okay. I'll start then with the first point. Many academics have bemoaned recently in stark terms the annihilation of any faith that constitutional law is anything other than maybe a little more sophisticated form of politics, or politics dressed up in legal language. Steve Smith, who's something of an idol of mine, he teaches at University of San Diego in the law school. He actually has written about feeling sleazy in teaching constitutional law, because we want to try to inculcate in our students a sense of they need to search for legal rules and take these things seriously. At the same time, the more time you spend with constitutional law, the harder it is to believe that anymore. And I could cite numerous other examples. There's Lino Graglia at Texas. Both of them, of course, are kind of on the right side of the political spectrum. In the last 10 years, though, in part, I think, in reaction to Bush v. Gore, and I agree and disagree with Professor Joondeph in terms of the consequences of Bush v. Gore. Obviously, the numbers, the polling tells us that the public did not really shift very much in reaction to Bush v. Gore. But I think Bush v. Gore set the tone for what has been a very bad decade in terms of the legal culture, the political culture, and the academic culture in terms of faith in a distinction between law and politics. So I think that, to say the court got away with it is true in one sense and false in another. But I think in part because of Bush v. Gore, you've seen over the last decade a number of left-leaning scholars who have been increasingly critical of the court and increasingly cynical about the notion of there being a distinction between law and politics. And this has not been a good decade for those who believe that there is such a distinction. I will not belabor the point, but you can cite a very long litany of highly politicized, socially important, and deeply divided cases that have been handed down in the last 10 years. Of course, starting with Bush v. Gore, Lawrence v. Texas, Grutter v. Bollinger, Gonzalez v. Raich, Gonzalez v. Carhart, Atkins, which is the mentally retarded death penalty, Roper v. Simmons, parents involved in community schools, Citizens United v. FEC, DC versus Heller, McDonald versus Chicago. Okay, and those are the ones I thought of on the plane ride out here. So I think that if you really went searching for them, you would find a lot more. But the fact that I can just list that name of cases, and most of you know what I'm talking about, shows that they're salience. And I think every one of them has, in different ways that I elaborate in greater detail in the paper, worked to undermine our faith in that confidence between, that there exists a distinction between law and politics. Okay, now, some people may say that that's good. It's something we've kind of got the wool drawn from our eyes. We see the reality. Now the justice can be openly political or something like that. I don't believe that would be a good thing. And also some may say, well, whether it's a good thing or not, it's inevitable. So, so now again the wool's pulled from our eyes, and at least we see the reality, as bad as it is. And we've always been this way and always will. I don't believe that, actually. I think that there's been an ebb and flow on this, and I think there have been times when the judiciary has been more self-restrained and self-policing, and times where it has been less so. And the third thing is, well, sort of, there's nothing we can do about it, or nothing they can do about it in the short term. And I think that's not true, because I think that the justices can make great strides towards recovering this notion that there is some law and constitutional law by engaging in what I refer to as judicial or constitutional forbearance. And succinctly, what I mean by that is that the single most effective way to exhibit the difference between law and politics is for judges to refrain from advancing what to them, and especially what to them patently, are politically desirable ends out of respect for the dictates of contrary constitutional law. A judge who exercises this sort of self-restraint in a constitutional case engages in constitutional forbearance, and I think we're in need of it now, and I think the Affordable Care Act cases present an unparalleled opportunity for the Roberts Court to exercise notable, noble, and again, healthcare metaphor, healing constitutional forbearance. Again, as I said earlier, law is a socially constructed reality. The meaning and significance of which is forever in the process of self-regeneration. In order for there to be law and constitutional law, there must be, among other things, patterns of mutually reinforcing judicial behavior that at once make judges look and be something other than politicians in robes. There's a sense in which I think that every exercise of constitutional forbearance is kind of an instance of unilateral judicial self-disarmament in faith and an expectation that that will be returned by one's colleagues. And so I think that every time it occurs, I think that it puts greater pressure on other judges to do the same when they're presented with temptations. And I think that every time it is an opportunity is missed, it frees judges. Well, if no one else is going to play by the rules, why should I? I'm just a fool if I actually try to play by the rules. Now, how does this work in practice? It would of course, be as inappropriate as it would be unlikely for this notion of dedication to posture of forbearance to manifest itself as a hostility to one's own preferred outcomes. Applied rigorously, this would be kind of a perverse anti-bias bias that would work distortion in the legal process that amounts to a mirror image of the slant it was adopted to cure. And when worse, it wouldn't even provide the benefit of reaching desirable, again in the judge's eyes, outcomes in individual cases. But I think there are types of cases that are especially well suited for the exercise of judicial forbearance, and I want to kind of talk about what I think those cases are and why the Affordable Care Act cases fit in that category. First of all, I think an important aspect of thinking about the kinds of cases that are ripe, if you will, for judicial forbearance is to think about the the state of the existing legal doctrine in the area. And as everyone has noted, the principal question on the merits presented in these cases is whether the Commerce Clause, alone or with the help of the Necessary and Proper Clause, grants Congress power to enact the individual healthcare mandate, health insurance mandate. Now, I think it's hard to find an area of the law more notoriously indeterminate than the court's current Commerce Clause jurisprudence. One of my friends and colleagues, Robert Bashaw, who teaches at Pepperdine, has referred to it, summarized it as analytical chaos. Now, the symposium has affirmatively ousted the discussion of the merits, so I'll be brief about this, but it seems to me that if you're to characterize the state of affairs, certainly I agree that it is a novel question, that both sides can claim that their defeat in the case will usher in a new and terrible regime. But it still seems to me that for our present purposes, that the case for federal power to do this is strong and straightforward, although I admit not ineluctable. Okay? It's intellectually respectable to go the other way, but it's easy for any judge to uphold this law under existing doctrine. I think the case against federal power, however, requires adoption of a restriction that, in Judge Silberman's words, is redolent of economic substantive due process. And that would be a restriction not so much on the scope, but the manner in which Congress can exercise its Commerce Clause power, even when it does so as part of a comprehensive regulatory scheme of what amounts to 17% of the U.S. economy. So I guess the worst that can be said about the Affordable Care Act is that it is without precedent, which means there's really no authoritative precedent for or against it. That is a kind of circumstance, I submit, in which lends a case more to an exercise of judicial forbearance than not. I certainly would not. I don't think the pull towards self-restraint ought to overcome clear doctrine. Okay? Again, that itself will be perverse and undermine the. I just realized my timer's gone. I guess you just will have me forever. I'm reminded of John Belushi opened Saturday Night Live one time where he was on the stage by himself, and he said, this is very foolish of Lorne Michaels to do this because the show doesn't start until I say those magic words. And then he brings out a piece of paper, I have a list of demands. Okay. All right. It would be absurd to allow this dedication to self-restraint or culture of self-restraint to actually overcome a clear rule. That would undermine the whole point, which is to make our constitutional law more law-like. The other thing that I think, this is a group of things, but it's under the category, one category that I think helps identify cases that are appropriate for judicial forbearance and constitutional forbearance, and also ones where it is particularly necessary are cases where they have been, to use Professor Hartnett's term, hyper-politicized. And I had some details here I was going to bring forth to try to make that point, but my colleague on the panel, I think, has already done that better than I ever could have. I mean, this really is in a almost singular category in terms of cases that have risen to the public attention. In the paper for this for the Law Review Symposium, I note that when in the past has a district court case led to a series of questions of the president in his pre-Super Bowl interview, okay? I mean, this is really, it's on everybody's mind, okay? And there are deep, deep passions on both sides about this. There were, of course, notoriously rancorous debate leading up to it over the course of a 12-month period. The 2010 elections were in part about whether this law should be retained. The Speaker Boehner's promise was that the first thing he would do was repeal the monstrosity, and the House voted to do so, though it was largely symbolic. And I think that, in particular, the way the litigation has been conducted has served to further politicize this issue. This morning, Professor Marshall talked about the way in which participation as a party or filing of an amicus brief by a state has taken on a significance that really has nothing to do with the legal doctrine, but has to do with a kind of counting of noses or showing political support. I think that the media attention to the case has reinforced that. I think the fact that the cases themselves have, with 3 notable exceptions, split perfectly down party lines in terms of appointing authority. That is, there are 3 judges who were appointed by 2 by Republican presidents who said, yes, the act's constitutional, and 1 appointed by a Democratic president who said, no, it's not, in terms of reaching the merits. And I will come to a close here. You've been rescued. I think the timing of the litigation continues to seriously exacerbate this. Obviously, everyone's expecting a decision in June 2012. I at first was shocked and disappointed and perplexed when the Obama administration sought cert in the 11th Circuit case. Now, part, I think, may be driven by the, I'm a huge fan of Kevin Walsh, and I agree with almost everything he says. But when he said in his remarks, I'm leading up to disagree with you, when he said in his remarks earlier that everybody wants the court to decide this, okay? Well, maybe it's everybody but me, okay? I actually would be fine if the court never decided this. I actually think that we can govern ourselves, even without the court's intervention. So I would be okay with that. But I think we're pushing towards that, and I think that one explanation for the petition for cert by the Obama administration is this: we need an answer, and the only way we get an answer is to count heads on the Supreme Court. The other calculus, though, is far more disturbing from my perspective, and that is that the administration looks at it and says, all right then, you know, we won a decision before 2012. We lose, we run against the court. We won, we use the decision like, we win, we use the decision like a club in the rest of the election cycle. That would be terrible, I think. But it may well be the calculus, and it may well be a sound one from solely from a political perspective. And this brings me full circle back to the fact that my comments actually do have something to do not just with the merits, but with the procedure. Because given the fact that there's now an increasingly complex risk that any ruling by the Supreme Court on the merits will have not only political consequences, but complex, unforeseeable political consequences, might properly push the court to the exercise of what Bickel called the passive virtues, and whether that's, now it seems like the best opportunity for that would be a ruling on the Anti-Injunction Act. And were the justices to decline this opportunity, to refrain from exploiting the one it gives to deliver a political black eye to the president, they would demonstrate by their actions what a less partisan constitutional law would look like. To be sure, were this to occur, it would be but a small step toward a transformation of our legal and political culture. But it may be a generation before another opportunity as significant as this one presents itself. There may never be a better opportunity for the Roberts Court, and for Roberts in particular, to the extent he's concerned about his legacy, to exercise constitutional forbearance, or what he called humility. Thank you.
Well, I feel singular in many ways, in addition to the fact that I have slides. But I thank you all also for having me here, Professors Walsh and Tobias and Amina and the wonderful staff of the Law Review for hosting this symposium. I do feel special that I get to speak last, which means that I'm full of ideas that we've been discussing all day, and I'll try to incorporate those as we go along. I also feel special being the only woman speaking, and also being the only health lawyer. So I specialize in healthcare financing and regulation. I'm not a proceduralist. I'm not a constitutional law scholar, although I write in the structural area with respect to healthcare. So for me, this issue, the question of the litigation over the individual mandate, is really only one piece of the larger picture of state resistance to this movement, or to the federal legislation. So I began working on the issue of state resistance some 2 years ago, before the Affordable Care Act was passed, and have continued to follow it since the enactment and during the implementation phase. So what I want to offer today is mostly a descriptive, on-the-ground update of the current state of play by states with respect to the Affordable Care Act. So I'm clearly beyond not just the merits, but really beyond the litigation per se. And what I'll offer are some descriptions and also some observations about the dynamics and the paradoxes. What I hope for this piece to be, the piece that I'll contribute to the law review, is more of a study or a sketch for a larger, more comprehensive theoretical piece, the working title of which might be something like muddled federalism, or dysfunctional functional federalism, or dessert buffet federalism, so that we get the layer cake and the marble cake and the picket fence, all of that in there. So to start with, I'm really working off of an earlier piece that I did that presents my views of the state resistance movement in the months before and the months immediately after the enactment of the Affordable Care Act on March 23rd, 2010. At the time, it seemed to be something of a flash in the pan, a curious movement among states to resist the federal legislation. We've talked earlier today about the Virginia Healthcare Freedom Act. A number of states had considered and enacted similar statutes before the Affordable Care Act and continue to enact those after the Affordable Care Act. But that wasn't the only movement of objection by states. Obviously, lawsuits, we've talked about that, filed within hours of President Obama's ink being on the federal legislation. And further, states registered their objection by refusing to implement certain pieces of the legislation that took effect immediately after enactment. Well, I think to many commentators, and maybe Randy Barnett being the one holdout early on, most of this seemed utterly without merit. The lawsuits seemed very weak. The Healthcare Freedom Acts seemed undoubtedly preempted. So the question was, well, what's it all about? And is there something important going on there? My earlier paper attempted to look at this movement and to not simply dismiss it as Tea Partyism or political theater, but to suggest that there's actually some value to it. The challenge that I found in the earlier paper was to try to come up with some comprehensive federalism theory to explain what was going on. And what I concluded was that it really doesn't fit in any one given theory, but that it might be explained in terms of a list of values, which I labeled rhetorical federalism. So what I want to do today, and for the paper for the law review, is to re-examine 5 different fronts of state resistance to the Affordable Care Act, litigation involving the individual mandate being just one of them, and also revisit these values of rhetorical federalism that I identified in the earlier paper. So the 5 provisions that I examined in my earlier article included Medicaid expansion, high-risk insurance pools, the state-based exchanges, insurance market reforms, and the individual mandate. The individual mandate, of course, has been the loudest front. That's the strongest attack that states have made against the Affordable Care Act. But to me, it's really the least intuitive. That's the provision that has the least to do with the allocation of power between the federal government and states. Other provisions, including Medicaid and the high-risk insurance pools, as well as the exchanges, those seemed like more natural outlets. Those really did involve a balance of power between the two parts of government. States were already participating in Medicaid. That's a classic example of cooperative federalism. The concern under the Affordable Care Act was that the conditions were being expanded. The burden on states was increasing. Additionally, the Affordable Care Act offered new opportunities for states to participate in collaboration or in cooperative ventures with the federal government. The high-risk insurance pools, which were to be in place the summer after the Affordable Care Act was enacted, and then the much longer and more complex process of implementing state-based health insurance exchanges. I also examined the federal insurance market reforms. We've talked about some of those today in connection with the individual mandate. Community rating, guaranteed issue, rate caps, or eliminating lifetime and annual caps, a whole array of new federal substantive insurance market regulations. And I used that examination really as a counterexample, because at least initially, that part of the Affordable Care Act, that exercise of power by the federal government, didn't draw particularly strong resistance from states, although from a structural view, if what we're really concerned about is states versus federal power, that seems like that should have been the focus. So the individual mandate then was the final point. And I think we've talked, again at different points today, about, in essence, the individual mandate is really about individual rights and personal autonomy and economic liberties. It's not so much about structural rights. So how is it that that's gotten translated into this signal Commerce Clause federalism question? All right, so let me revisit the 5 fronts and describe for you a little bit about where they stand and what the new tactics are. So Medicaid expansion. This symposium, of course, is on everything but the merits, so I won't say very much about the merits of the state's Medicaid challenge other than to agree with the 11th Circuit and with Judge Vinson that it's basically a loser of an argument, that I think this is a weak argument. The Medicaid program is a voluntary program that states have the option to participate in if they choose to. If they choose to participate and comply with broad federal guidelines, they receive federal dollars for doing so. Well, the Affordable Care Act does expand Medicaid and thereby places a larger burden on states, but states still have every right to refuse to participate in that program and decline the federal funding. They have plenty of notice, The federal government will bear the burden of this expanded Medicaid program fully, 100% for the first 2 years of its taking effect in 2014, and up to 90% indefinitely thereafter. And these are some of the points that were made in the 11th Circuit opinion, rejecting this challenge by states. So that argument, the state constitutional challenge to Medicaid, seems weak. The new tactic by states instead has been to demand Medicaid in a different way. States still want Medicaid federal funding, but they don't want the Medicaid, the federal conditions. So there's a movement to seek block grants by states. This slide is for the Kaiser Family Foundation, showing that this suggestion is not wildly popular. The argument from states is that they can run the program leaner, more efficiently. They will be capped effectively in spending if they receive one block grant rather than matching dollars. There won't be the same incentive for inflationary spending. And moreover, consistent with classic federalism values, states can tailor their Medicaid programs to state, local needs, populations, and concerns. The opposition to this movement is a concern that states might be too lean, that they would start to dump needy beneficiaries out of the program in order to stay within their budgets, or might just fail to stay within their budgets and require more federal funding. But interestingly, despite this movement for Medicaid block grants, what states are not doing is, one, declining to participate in the Medicaid program. States are not opting out, although they could, and there was some faint threat by Governor Perry on that early on. The other thing that states are not doing is pushing for full federalization of Medicaid. If it is such a burden on states, it seems the movement should be require the federal government to do it. So what I suggest, at least my observation out of this debate over Medicaid, is that maybe it really is an example of cooperative federalism, the way the program was designed, working, at least in a dysfunctional, functional sort of way, because no one is really seriously willing to rewrite the approach to Medicaid. We're not really ready to rock that boat. So Medicaid expansion. Well, the second part of the program that I looked at in the earlier paper was the pre-existing condition insurance plan. These are the high-risk insurance pools. The default under the Affordable Care Act is that it was the federal government's, HHS's, responsibility to establish high-risk pools beginning July 2010. And those were to be in place until January 2014, when the exchanges, guaranteed issue, modified community rating, tax credits and subsidies, Medicaid expansion, all of the other substantive federal reforms would be online. The idea is that people who have been unable to obtain insurance for 6 months and who have pre-existing conditions could get insurance through these temporary pools. Well, it was primarily the Secretary's option, the Secretary's responsibility, but the Secretary had the option to contract with states or nonprofits in order to set up those high-risk pools. Initially, because this was one of the first provisions of the Affordable Care Act to come online, there was considerable rancor. Several states took the opportunity to loudly reject the Secretary's invitation to set up their own high-risk pools, to refuse that cooperation. But after the dust has settled, we see that this is a map showing the green ones are the federal high-risk pools, and the yellow ones are the states that wanted to do it on their own. But the dust has kind of settled out. It's fairly evenly divided. There's no apparent tension. There doesn't seem to be much confusion among enrollees about whether their program is state-operated or federally operated. It seems to function. And to me, this seems to be an example of what Professor Rick Hills calls functional federalism, or a New York entitlement, the idea being that states retain the right to refuse or to decline an invitation from the federal government to contract and to use their administrative services to carry out federal functions or federal policies. But if they choose to enter that contract and accept the federal dollars, they can do so. So this seems to be working. States have made choices, and we have a program that's a hybrid federal-state program without an apparent dysfunction there. Well, it gets more interesting when we start talking about the health insurance exchanges. Again, the Affordable Care Act allows for alternatives, federal or state. But the default under the Affordable Care Act is that exchanges will be state-based. Exchanges require a much more significant implementation burden and a much longer lasting obligation on states. So there, not surprisingly, is more diversity of reactions. The deadline for states to demonstrate their readiness to have an exchange in place is January 2013, but the exchanges have to be up and running by January 2014. So it seemed to me that if what was going on with this state resistance movement, if it's really about structural issues, it seems that states, if they're serious about the allocation of power between the federal and state governments, would favor state-based exchanges. And that seems to be true, for example, here in Virginia. Virginia, of course, is challenging the constitutionality of the Affordable Care Act, but at the same time is up and running, has legislation signed, and is prepared to carry out a state-based exchange should the litigation go the other way. Well, that seems consistent. On the other hand, there are states that are actively resisting and actively, I don't know if you can say actively foot dragging, but at any rate, are not making steps forward to establish these state-based exchanges. Further, some states have noisily returned federal funding to establish their exchanges. Kansas and Oklahoma, in particular, initially applied for and received substantial federal early innovator grants for exchanges, and then later returned them. The argument by opponents seems to be contrary to the suggestion that I made, that states that are concerned about too much federal power would want to keep exchanges operated by states. The idea seems to be that enacting any sort of program that is under a federal requirement is effectively a federal cram down, and states therefore must not do anything to move forward in terms of establishing the exchanges under the federal law. So returning grants, not applying for grants, vetoing legislation, or simply sitting on their hands seems to be the approach of some resistant states. And this overall strategy may be similar to the movement in Congress to block appropriation of federal funding for implementation. Here, again, maybe to attempt to cripple the overall implementation of the act. This one, it's hard to say what's going on because it's still playing out. It seems that if the strategy works, if states can truly obstruct implementation by not setting up state-based exchanges, then this may be an example of states using their power as potential servants to the federal government in order to change the substantive legislation to effect that sort of policy change. On the other hand, if states resist and if the federal government, Health and Human Services, can effectively establish federal exchanges in those resistant states, as we saw with the high-risk pools, then we may see a similar sort of happily coexisting federal and state programs, more of a marble cake federalism approach. I mentioned that in the earlier paper, I was interested in the fact that states did not seem to be resisting federal health insurance regulations. This significant change in the role of the federal government with respect to regulating a particular industry. For much of for a very long time, this has been traditionally the domain of states, regulating healthcare providers in terms of licensing, regulating healthcare insurance in terms of licensing and consumer protection laws, substantive regulation of the content of health insurance policies. Well, now the federal government has taken a much more active role in those industries. Yet there seemed to be little resistance from states on this point in particular. There were some objections, at least to the Affordable Care Act more broadly, and that objection did spur President Obama to back an amendment to fast-track a particular provision of the Affordable Care Act, Section 1332, which allows the Secretary to grant states comprehensive waivers from many key provisions of the Affordable Care Act, including the individual mandate, exchanges, the employer penalties, the essential health benefits definition, the distribution of federal tax credits and subsidies, and the amendment would have moved up the ability of states to obtain those waivers from January 2017 to January 2014. Well, again, if states care about retaining their own authority, it seems they should be running after this. They should be really seeking out this opportunity. Yet few states and no litigant states have sought waivers. The most notorious waiver is the Vermont single payer system. It's a Section 1332 waiver allowing them to establish a very different program in that state from the federal government's Affordable Care Act. The states that have not taken this invitation fault the program as being a gimmick, really too onerous. Effectively, what the implementing regulations for Section 1332 provide is that states have to do as good of a job in terms of coverage and cost-sharing protections, have to provide as comprehensive coverage as the Affordable Care Act, but have to do it without incurring any additional cost on the federal government. So in a sense, maybe a fool's errand, and that may be the reason why states have not taken advantage of that opportunity. At the same time, however, states have sought waivers to more incremental portions of the insurance regulations, most specifically the medical loss ratio, or a requirement that insurance companies have to demonstrate that they are spending 80% of their premium revenues on actual patient care and only 20% on overhead. There is a regulation that allows states to obtain a waiver from that if they feel that it will cripple or endanger the insurance industry within their state. And some states have obtained those waivers, using that or pointing to that as a signal, perhaps, of a larger move towards overturning the entire act. So the upshot here is that, at least what I think may be going on here, is that the insurance market reforms, in particular provisions like the ban on pre-existing condition exclusions, post-claims underwriting and rescission, caps, community ratings, those provisions, of course, have very broad popular appeal. Those are the things that we've complained about with managed care for decades. So for states to come out strongly against those sorts of consumer protective reforms, even though they're included in the federal legislation, is difficult from a political perspective. It's a tough line to walk. It's an even tougher line to walk, however, given that the focus of states' challenge is on the individual mandate. And as we discussed before lunch in the severability context, it's hard to support these other parts of the health reform legislation, these other insurance industry reforms, while also striking down the individual mandate. It may not be that those two positions can operate. So the last front, and what I suggested was the least intuitive front, is the individual mandate. And I know we're not here to talk about the merits of litigation, but this is just a reminder of the 28 states that are involved in the lawsuits, the red states being the ones on the Florida lawsuit, and then 2 states that are litigating as individual plaintiffs, Florida and Oklahoma. Of course, there are also individual litigants challenging the individual mandate, as well as the employer penalty, and we talked earlier about the Medicaid legislation. So again, to me, it seems that the challenge to the individual mandate is beyond question about individual rights, about economic freedoms and healthcare freedoms, but that there's really not much strength to those claims from a constitutional basis. Hence, we have these structural challenges to get at the same concerns. So setting aside the lawsuits, which I think have progressed farther than many of us would have predicted, states, quite interestingly, continue to oppose the Affordable Care Act through state legislation. And it seems somewhat quixotic to me that states are continuing to pass healthcare freedom acts, even after an ACA enactment, even in the face of obvious preemption, and even as Virginia got tossed out on standing grounds precisely because it had enacted a Healthcare Freedom Act. So to date, we have 17 states that have passed legislation opposing elements of the Affordable Care Act, almost always targeting the individual mandate, but also other provisions. Legislation has been introduced in 45 states, including several binding and non-binding resolutions that have been introduced in 2011, well after the Affordable Care Act's enactment. And there are ballot items set to go in 2012 as we move forward. And even curiouser, to borrow from Alice in Wonderland, are the healthcare compacts. So essentially, the idea here is that they're healthcare freedom acts, but with a purported interstate overlay. There is a compact clause of the Constitution that states are invoking to propose these laws, but the idea seems to be that somehow states can avoid obvious preemption, and as long as they agree amongst themselves that federal law does not apply, that somehow that will have greater effect than individually enacted healthcare freedom acts. These healthcare compacts also purport to free states of federal funding conditions, bestowing themselves Medicaid block grants effectively. What's curious about it is that these compacts undoubtedly are subject to congressional approval. They must be passed like any other federal law. Yet 4 states with great fanfare, the green dots, have enacted these compacts. The blue states represent an additional 11 states that at least have introduced legislation on this front. I spoke at the National Conference of State Legislatures conference this summer right after Texas had passed its healthcare compact, and I spoke to the sponsor of the compact, came up and spoke to me after my talk, and I had done sort of a Federalism 101 kind of talk to this group about supremacy clause and the 10th Amendment, and she came up and seemed very curious. Now what is that exactly that you're saying? And it seemed to be almost this unawareness that this was pure folly, that these laws had no legal effect at that particular point, which I thought was fascinating. But I think that, so either states simply don't get it, or they're taking the suggestion that this is one tactic to signal objection to the federal health reforms, that they're signaling serious objection, and that maybe that, along with everything else, will make a difference in Congress, in the courts, to the extent courts consider the politics, and perhaps as well to the electorate down the line. So, and I haven't paid any attention to where I am on time. Okay, great. So testing the values. So now that we've seen a little bit more about where the state of play is, some 2 years out, do these values of rhetorical federalism that I observed in the earlier article, do they still work? Well, one of them was that I suggested that the role of states, the state-based resistance movement, was valuable in terms of highlighting the implementation complexity of the Affordable Care Act. As states rolled out their objections one by one and continued to press against the act even after enactment, we might have a better understanding of just how difficult these issues are, how much is involved both at the federal level, the state level, and the administrative level in terms of getting some major comprehensive piece of legislation like this into effect. Well, I think that's still true. I still think that it's safe to say that the average American knows more about the interaction between states and the federal government and the role of agencies and the operation of the health insurance industry than they did before the Affordable Care Act. And I think that's a valuable thing. Additionally, I suggested that the rhetorical federalism has an effect of educating the public, that again, as states continue to challenge the pre-existing condition pools as they come online, the exchanges as they come online, one by one, it allows the electorate to think about these issues in more discrete ways, rather than as a 2,000-page piece of legislation that they must try to distill all at once. I also suggested, and again, I think that one continues to be true, giving voice to minority views. Again, this is a classic value of federalism, the notion that local and state representatives are more accessible and more accountable, may have room to offer a more diverse view than is expressed at the federal level. And I think that on this point, it's not clear to me whether the outspoken state representatives and officials challenging the Affordable Care Act whether they truly represent their residents' preferences. It does seem to be true that support for the Affordable Care Act is declining. We've heard statistics earlier today. The Kaiser Family Foundation survey as of October, for the first time, registered objection over 50%, 51% of respondents are unfavorable towards the act. So maybe there is a true representation of what was a minority view now becoming a majority view among the electorate. But I'm not sure that from a federalism perspective that it's particularly important that this opposition is coming from states or state officials as opposed to national channels. So that particular value of rhetorical federalism, I question. Well, the one that I particularly question, and I'm actually rather embarrassed by now, is the suggestion that by channeling these objections to the Affordable Care Act as structural federalism arguments as opposed to substantive arguments on the merits, that we might depoliticize, that we'd focus more on the structural concerns and get away from the weeds of the actual merits or structural objections. Well, the federalism arguments, of course, have certainly not diffused the rancor or calmed substantive objections. They have become the arguments. And that's in part, as I suggested, because the substantive arguments, the individual rights arguments, really aren't winnable. So this is a very different outcome than I would have predicted in the earlier paper. Codifying dissent. The suggestion here was that even if states are passing these seemingly null healthcare freedom acts that are obviously preempted and cannot stand in the face of contrary federal legislation, then maybe they serve an important role in terms of being laws that are on the books but not effective, so that if the Affordable Care Act is repealed in whole or part, they would signal that objection, they would codify that dissent. And if we start to have this conversation again about how to reform the healthcare system, at least we'd have that starting place to work off of, that sort of codification. And I think that that one probably continues to be true. It's not clear what would happen with these healthcare freedom acts should the Affordable Care Act be overturned. Would they spring to life? But it certainly seems to signal a view among the majority of states about federal-state power dynamics and the importance of thinking about that as we move forward in reform. The last value of rhetorical federalism that I suggested was highlighting the government's role in healthcare, and certainly I think that is true. No question that we now appreciate the very active role of both the federal and the state governments in the healthcare industry. But I'm not sure we have any clearer consensus on whether that's desirable, whether we want a stronger government hand on this industry. My idea in suggesting this in the earlier paper was that maybe this is sort of a way to get the electorate to start thinking about the importance of government and healthcare, maybe sort of paving the way towards some sort of single payer system. If we get comfortable with the idea of government and why they're there, we could get closer to that. And I don't think we're any closer to that. We're probably farther from the notion of a single payer system. So my upshot in terms of describing this, as I said, muddled federalism, where we have a variety of approaches, various states opting in or opting out, states seeking money, willing to be financially dependent on the federal government but not wanting to have strings, their willingness to but unwillingness to fully disengage or to fully own health reform, suggests this sort of dysfunctional functional federalism. It seems to me that this kind of diversity, this messiness, is part of what's good about our federalist system, that it allows us to find optimal solutions that sometimes involve states alone, sometimes involve the federal government alone, and sometimes involve some cooperation. I was reading an old Arthur Miller article from 1958 on the plane as I was coming out here, and it was interesting that he made some observations about Helvering and Stewart Machine, the cases upholding the Social Security Act. And in Miller's view, those cases, which are not about a cooperative federal-state program, they're about a federal health care or federal public benefits program, he characterized those cases as giving final constitutional approval to the outlines of cooperative federalism. So the idea being that the federal government is setting the policy agenda, but states effectively are carrying it out. In the Social Security context, really only in the sense of it being a state or a payroll tax. But his further suggestion was that once breached, this dam, this has never been repaired. The trickle became a stream and then a flood. And he said that today, that being in 1958, the federal grant and aid is in principle a way of financing new activities of state government. So while we focused so much of our discussion in terms of the merits of the Affordable Care Act legislation on Wickard, a 1942 case, it's really this 1937 precedent regarding the Social Security Act that laid the groundwork for the current debate that we're having. Well, just to conclude, and Arthur Miller's suggestion in his paper was that he was really looking at a larger question of the role of corporations and a different view of functional federalism than what I've described. But to him, this question of state and federal relations was largely settled. Well, we certainly have seen that that's anything but true, and the debate is very much active. So thank you for indulging my thoughts.